Yes. Shall we call the case on, please?
This is an appeal in the matter of QY, Vietnam and Secretary of State for the Home Department.
Thank you. Yes, Mr. Georgie.
My lords, good morning. I appear for the appellant in this appeal, QY, been anonymised to.
Yes.
My learned friend, Mr. Keith, appears for the respondent,
Yes.
Secretary of State. I was proposing to start with paperwork, tentatively.
Yes.
The court ought to have an appeal bundle. I, for my part, am working on an electronic bundle.
Yes, the page numbering doesn't quite marry up with the paper index, unfortunately.
That was my concern. I had it.
If you just tell us the hard copy page number and the electronic bundle number, that'd be good.
I hope that that's been corrected, because the paper copies that had been filed with the court, I had instructed my solicitors to correct that, and I hope I won't have to give you two numbers each time.
Okay. Well, we'll see how we get on.
Thank you. In addition, the court should have an authorities bundle, to which
Yes.
not great attention will be paid, although my position is that this appeal doesn't really raise an issue of principle.
Okay.
We are concerned with a decision of the First-tier Tribunal. Finally, I hope the court has a skeleton argument, a replacement skeleton argument, which was dated the 25th of March. If not, I have brought 3 paper copies.
Yes, and I've got one, 62 paragraphs, 25th of March.
Yes, I'm grateful. Thank you.
Yes, I have that.
I don't have that.
Look like James.
Yeah, I've got it electronically.
In that case, my lord, if I could potentially, I do apologise.
And just whilst we're identifying the documents, on Mr. Keith's side, I think what I believe to be the final skeleton is respondent's skeleton for court submissions. Thank you. Dated 1st of October 2024.
Excuse me.
It's okay. It's all right. Sorry. Is that right, Mr. Keith?
My lord, yes, although there was a version filed, I hope, last week with the page numbers added to it.
Right, okay.
If not, then I'll just refer to the page numbers.
All right, thank you. Yes, so Mr. Jury, I think we're probably okay on the paperwork.
I'm grateful. Just to round that off, that skeleton argument should be pages 149 to 157 of the appeal bundle.
Right.
Sorry, you said that skeleton argument, yours or his?
Forgive me, the respondent skeleton argument.
Thank you, sorry.
To which you were referring. There is one matter, the matter of anonymity, which hasn't been addressed in the written submission.
Well, he's been anonymised so far.
Yes, my lord.
Obviously, we'll need to consider that as part of the order, but you ask for the anonymisation to continue.
Yes, my lord.
Mr. Keith, do you particularly oppose that?
No, I submit that should continue.
No. Well, for the time being, at any rate, we'll carry on as we have been. If anything changes at the judgment stage, we'll indicate accordingly.
Thank you. Just to give an estimate of timings, I have set out my submissions in writing in my replacement skeleton document. And as I've already suggested, in my view, the issue is a fairly narrow one. So hopefully it means I can be relatively short in my submissions today, and I anticipate that I should be finished by midday.
Thank you.
Although I appreciate the court may have different ideas once I start. But
there's always the possibility of a question.
Thank you.
Remote though it is.
So the issue for the court in this appeal is, in essence, whether the First-tier Tribunal erred in law in the way held by the Upper Tribunal at paragraphs 59 to 69 of its decision. my submission will be that it did not. And if the court agrees with that submission, it will be invited to remake the Upper Tribunal's decision under Section 14 of the Tribunal Courts and Enforcement Act by dismissing the Secretary of State's appeal to the Upper Tribunal, and that would have the effect of upholding the First-tier Tribunal's decision. The structure of my submissions, I wanted to start by tracing through the Secretary of State's grounds which challenged the First-tier Tribunal's decision through to the Upper Tribunal's decision on those grounds. I thought that might be helpful because that means I can exclude the other grounds, because
Yes.
you've seen there are various other submissions made which didn't make it. So I'm hoping that can narrow down the consideration of the background, which I will then go through and then address you on the First-tier Tribunal's decision and make my submissions. So the starting point for the grounds is the application by the Secretary of State for permission to appeal, and the grounds within that application you can find at page 43 of the appeal bundle under section C of the template pro forma application form, reasons for appealing. As you will, as your lordships will see, ground 1 was an alleged misdirection of law in relation to the humanitarian protection ground of appeal. It was said that the first-tier judge had failed to consider that the appellant was excluded from humanitarian protection by virtue of his conviction. In essence, paragraph 4, which is on the following page, argued that the first-tier judge had conflated the test under 339D of the immigration rules with the familiar test under section 72, which is relevant to the Refugee Convention. It was said that it was an error simply to adopt the reasoning in respect of section 72 when it came to 339D. As the court will come on to see, that's not an argument that was accepted by the Upper Tribunal, precisely because they are the same test. And I note that that ought to have been apparent from paragraph 2 of the grounds, where at subsection Roman numeral 4, it's quite clear that constitutes a danger to the community is also a part of the test under 339D. I will not say much more about that ground because in the end it was not accepted. Ground 2 is then set out as a failure to give adequate reasons for findings. I start out of order with paragraph 6, because that's also a submission that wasn't accepted by the Upper Tribunal judge. That relates to the issue of the appellant's failure to claim asylum in the other safe countries, which he had an opportunity to do so. And it was eventually treated by the Upper Tribunal as a separate aspect of this ground. It was argued by the Secretary of State in these grounds that there was insufficient consideration by the first-tier judge as to the appellant's failure to do so. And that is, I will refer to that as the Section 8 argument, based on Section 8 of the Asylum and Immigration Treatment of Claimants, etc. Act 2004, which the court should have in the authorities bundle behind tab 1. Paragraph 5 is really where the heart of the issues that arise today to be found. This is the part that the Upper Tribunal goes on to accept. And paragraph 5, in essence, describes itself as a challenge, a reasonings challenge. And 3 complaints are made. One is that there is no adequate scrutiny as to why the appellant has not sought to pursue the allegation he was detained, ill-treated and subjected to extortion with the authorities in Vietnam. 2 is that the first-tier judge failed to consider that any ill treatment was a result of an abuse of power by an individual against whom the appellant had a right of legal redress. Thirdly, the first-tier judge failed to consider that sufficiency of protection is available from such abuse. I pause there, if I may, because I will go on to make the submission that the difficulty with an argument that sufficiency of protection is available from such abuse in this particular case is that issue was not before the first-tier tribunal as a consequence of a concession that was recorded by the first-tier judge and again confirmed by the Secretary of State's representative before the Upper Tribunal, that the challenge was only to the first-tier tribunal's assessment of past events, not future risk. And perhaps it's stating the obvious, but the issue whether sufficiency of protection is available when a first-tier tribunal is assessing the issue of future risk is clearly a central question. But where it's been conceded that if an appellant is found credible, then he succeeds, the issue of whether sufficiency of protection is available is relevant only insofar as it relates to the issue of credibility of past events or a plausibility point. In essence, because sufficiency of protection was available, it's implausible that you didn't go seek it out. I also observe that, as the court will come on to see in the grant of permission, that these grounds are not particularly either clear or related to what they say they're supposed to be related to, which is an error of reasoning. It's almost could be said that a failure to consider a point is not quite the same error as an error of reasoning. When we come on to the grant of permission that you have at page 48 of the appeal bundle.
Well, is that right? And if a judge dismisses an argument but gives no reasons for dismissing the argument, why is that not inadequate reasoning?
Well, I would accept that it could also amount to a failure to consider a material matter.
Yeah.
Could also amount to an error of reasoning. But it might be a freestanding error on its own. But in any event, I have tried to address that error when it comes onto my submissions as both in the alternative. The grant of permission, which, as I have indicated, you should have page 48, does not, in essence, have much praise for the Secretary of State's grounds. The first thing to note, although does not particularly bear upon the issues before this court, is that in paragraph 2, the permission judge describes the grounds as being in respect of the section 72 issue and in respect of the grant of article 3 leave. That is not entirely accurate because of course the first ground was related to humanitarian protection and the argument was simply that's not the same as section 72. But at paragraph 3, the commission judge, in essence, for himself, goes on to consider the decision and identifies an arguable error in the judge's substantive treatment of the section 72 issue and its finding that this appellant is not a danger to the community.
Can you explain to me what the relevance of this document is? I mean, it's part of the history, but the decision was to grant permission, and hence there was the matter before the UT. So why does the reasoning matter?
Because it's not the case that an upper tribunal, following a grant of permission, can simply embark upon a free analysis of whether there are errors of law. The upper tribunal is restricted by the grant of permission.
To be sure, but permission was granted on both grounds.
Yes, and I'm not going to spend any great deal of time dealing with it, because as the court will see, the Secretary of State's skeleton argument then improved upon or expanded upon the grounds. But I considered it helpful to take the court through the background of the ground of appeal to see ultimately what the ground for the upper tribunal was. So I don't dispute that this, I've described it as having misdescribed what the ground said. It didn't mean that the Secretary of State was not permitted to argue, and in fact, the skeleton argument then proceeds to argue the substantive section 72 point. If an issue had been taken, it would have had to have been taken in the upper tribunal, effectively saying that we had no idea that that was going to be raised. The relevant part for our purposes is paragraph 5. It says, of course, I've already alluded to, that the grounds were not clear, but presumes that they are a reasoning challenge. The permission judge then goes on to observe something which hadn't been raised, which was, as an example, the judge in the first year had said that she had serious concerns about credibility, but then says that the appellant was credible, and that is sufficient to persuade the permission judge to grant permission as an arguable point in terms of the lack of explanation and inadequacy of reasons. In the final concluding paragraphs, the criticism is made, and as a result, the upper tribunal directed the Secretary of State to file a further skeleton argument, which she did, and the court has at page 50. Briefly taking you through this, round 1 is addressed at paragraph 6 to 14, and as I indicated a moment ago, the Secretary of State took up the opportunity to address the substantive treatment of section 72 following the permission judge's invitation, although that is eventually rejected by the upper tribunal as well, so I don't need to say more about that. And then fast forwarding as well to other matters which I don't need to say more about. Paragraphs 19 through to 28 of the skeleton argument attack the First-tier Tribunal's decision on the section 8 point, which was the delay. Again, that is a matter which the upper tribunal goes on to find the First-tier Tribunal had not erred. So, focusing in finally on the relevant part, these can be found at paragraphs 15 through to 18. And at paragraph 15, in essence, this is a repetition of the 3 points made in the grounds of application. And paragraph 17 and 18 expand upon those matters after paragraph 16 describes the First-tier Tribunal's reasoning at paragraph 32 of the First-tier Tribunal's decision. The 3 points made in paragraph 17 are: 1, the finding that the appellant could name the corrupt official, the head military recruiter, and the head of police linked to him was an inadequate explanation why the appellant would not have sought judicial redress. Secondly, having accepted that in general there is a due process, the First-tier Tribunal failed to give any reasons why the appellant's fear of reporting in 2010 could be probative of the issue of judicial redress. And thirdly, it's observed that all the First-tier Tribunal appears to do is to find the appellant's credibility is not damaged because he can name those two individuals, which is the same point being made in the first sentence. Paragraph 18. This is where the Secretary of State attacks the First-tier Tribunal's treatment of the concession. And I pause here to note that when it came to the Upper Tribunal hearing, this point was not pursued. And I'll take you to the concession made by the Secretary of State's representative. But here it's being said that the treatment of the concession by the First-tier Tribunal was inconsistent with submissions made about due process, both in the refusal letter and before the First-tier Tribunal. So what was not being done, this was not an application to withdraw that concession, it was being suggested that there was in fact no such concession. As I've indicated, that's not the point that was subsequently pursued in the Upper Tribunal. Finally, the final point, which we can extract from these paragraphs, second part of paragraph 18, it said that the First-tier Tribunal failed to make any findings at all as to why the appellant had not pursued the stay in court rather than paying the bribes, which the law says he was not required to do. Now, having identified what the arguments were before the Upper Tribunal, I wanted to turn to two of the three preliminary observations the court may have seen in my submissions, in my spoken argument. The first is to emphasise that in my submission there was no rationality challenge or perversity challenge being run by the Secretary of State. And secondly, the point that I made, which is that in the light of the concession, the only issue was whether or not the First-tier Tribunal had erred in respect of past events and the account that the appellant had given.
So you referred to the concession and where it's there. It's not obviously in paragraph 18. Where do you say the concession is made?
Forgive me, the original concession in the First-tier Tribunal's decision we found at paragraph 51 on page 36 of the appeal bundle at the bottom, where it says Mr. Brown told me. In essence, provided that he'd been able to rebut the presumption of exclusion on criminality grounds under section 72 or 339D, then the respondent accepted he should win if found credible as regards the claimed events in Vietnam.
The 72.2 presumption.
That's the danger to the community presumption. So if one is convicted of a crime and receives a period of imprisonment of more than 2 years, there is a rebuttable statutory presumption under section 72 that that is a particularly serious crime and a person constitutes a danger to the community, and that is grounds for excluding that person from protection on the grounds of their criminality. I'm sure the court will be aware of that.
Yeah.
339D has the same test.
But 51 is simply saying, is it not, that if you find the issue of danger is not there and the man is credible, then the appellant is credible, then he'll succeed in his appeal. That's not saying that you don't need to give proper reasons for finding that sufficiency of protection is neither here nor there.
No, but it comes back to the point I think I've already made, which is that the relevance of sufficiency of protection is not your standard one in an asylum appeal where future risk issues are large.
No, I understand that, but when the Upper Tribunal's criticism, as I understand it, was they have all these protections available. It's bizarre that when he was in Vietnam and changing cities, he didn't do anything about it.
Yes, it's
And that is not excluded, is it, by this concession?
no.
No.
So far as it's relevant to the plausibility of the past account, of the account of past offence, then yes, of course it's relevant to the issues. And that is at the heart of this appeal. But the reason I stop here is because several of the submissions that I've taken you to, indeed the submission that sufficiency of protection is available and that this man has a right of judicial redress, those are submissions which are couched in language familiar to asylum tribunals, that a tribunal is dealing with the issue of future risk.
But it might also have been read as attacking the findings that the FTT judge didn't actually grapple with that point.
It has to be read that way.
Yeah.
That's the only way it can be read.
Yeah.
So I'm prepared to deal with that.
Yeah.
But I wanted to stop because it is more common in a First-tier Tribunal appeal hearing. The issue of sufficiency of protection is raised further down the analysis after credibility. And my point for emphasising this is that that issue was conceded. In effect, if this appellant was credible that he didn't seek out sufficiency of protection, and if that is reasonably plausible, then that is the end of the analysis.
Yep.
The issue of sufficiency of protection is available in terms of future risk was conceded.
Thank you.
Just to round off that point, because of the suggestion that paragraph 18 of the skeleton argument before the Upper Tribunal that wasn't correct, and if I take the court to the Upper Tribunal's decision, where the representative, Mr. Tufan, this is recorded.
And these were both
42.
Home Office presenting officers, I think, weren't they?
That's right. Yes.
Yeah.
Page reference.
So it's from 64 over the page to 65, paragraph 42 of the Upper Tribunal's decision. And they address the concession about which we've just been discussing, and records at the end, Mr. Tufan agreed that in the circumstances the error of law challenge could only succeed if it was shown that the judge had materially erred in her assessment of the appellant's account of past persecution. That, in essence, is clarifying, I think, paragraph 18. There was a suggestion that there was more to it than that. So that is the second preliminary observation that I wanted to make in my final submissions, which I think I've made. The first was the fact that there is no perversity challenge, so it's not being argued that the First-tier Tribunal reached any irrational findings of fact or findings which were not open to her. If we then proceed to the Upper Tribunal's decision, then I can hopefully filter out the parts which are not relevant to this court's exercise. Up to paragraph, forgive me, the decision can be found at page 58 of the bundle. Up to paragraph 29, Tribunal sets out the background, and then from paragraphs 30 to 41 rehearses the history of the ground of appeal, which I've just taken the court through. As we've just seen, paragraph 42 deals with the issue of the concession. And then from paragraph 46 deals with the error of law submissions. The judge does start by referring to recent authorities for the essential proposition that an appeal court needs to show appropriate restraint before interfering with a first instance decision, not a controversial proposition. Then paragraph 47 deals with ground 1 and identifies that the original way that ground 1 was argued was conceived, and then at 48 to 54 deals with the reformulated complaint based on the grant of permission and rejects that. So ground 1 is not made out. Then paragraph 55, the Upper Tribunal judge turns to ground 2 and identifies what are essentially two overlapping challenges. One relates to the section 8 issue, the First-tier Tribunal erred in the way she approached that. The judge in the Upper Tribunal rejects that ultimately. And then from 59 to 69 we come on to the reasons why the deputy judge accepted that the first tier had erred in law. Of course, it may be necessary to return to this in more detail, but in essence, the deputy judge summarises his reasoning at paragraph 69 and finds that the first tier judge erred by conducting a flawed credibility assessment, which didn't adequately engage with the central reason in the refusal decision, that is, the existence of the martyr certificate, which gave the appellant an exemption from military service, and the availability of due process, by which the appellant could employ that. And secondly, an error of reasoning in respect of why the appellant was found credible, notwithstanding the serious concerns which were noted, and that was the point made by the commission judge on granting permission to the Upper Tribunal. Having done that, perhaps it was a laborious exercise, but my plan was to try and narrow down what this court has to consider, and I hope now that I've done that, I can take you through the background, so the facts relatively more quickly. The court has both of the appeal bundles. I say both of the appeal bundles. These are now routinely joined together in one hearing bundle, which the court should have at pages 158 to 457 of the appeal bundle. There is a background set out in my skeleton argument relating to the convictions, so the court has the sentencing remarks and details of the criminal convictions. The court has the details of the first encounter with the appellant as a seaman deserter. I wanted to briefly take the court to the first point at which this appellant raises his claim, and how he does that. He does it by way of a handwritten letter, which the court has at page 377. In essence, he gives a very brief background of his life.
Sorry to interrupt. Was that before or after the interview?
This is before, so this is the first
This is the first time
occasion.
it's raised. Yeah.
So explains that he was
And sorry, 337. I've got
377. Forgive me.
Oh, sorry,
Forgive me.
377. Sorry, I must have misheard.
The appellant starts by explaining that his late father had served and had been injured in action during the 70s. He later died of his injuries, and because of that, he had been awarded a certificate exempting other family members from having to serve, and concludes effectively that means I don't have to go to the army. So it was always his claim that he should have been able to have an exemption from military service. And it was always his claim that he had a martyr certificate, which should have entitled him to that exemption. If it's going to be argued that the First-tier Tribunal didn't have that in mind, I'm going to submit that cannot possibly be right, because it was always the essential basis of this claim from the very beginning. The reason why this appellant claimed asylum and wasn't able to obtain or vindicate his right to an exemption was in essence because there was an abuse of power by rogue officials, the head military recruiter in his local area did not accept the certificate and in essence detained him and tortured him for 2 days, requiring the appellant and his family to pay a bribe of 30 million Vietnamese dong, roughly £1,000 or 1,500 US dollars, which he then proceeded to have to pay every year. He explains that in 2012 he started working on cruise ships, and he would come back yearly and they would require him to pay on each time he returned. But that in 2016 he decided to complain and wrote complaint letters to government departments. That didn't result in any change. Indeed, he was tracked down again by these men and beaten up on 2 further occasions and subjected to torture again. The court will then find the appellant's asylum interview, the transcript of his asylum interview, from page 392. Question 7 was asked why he can't return to Vietnam. He gives.
And when they say witness statement, is that the reference to the letter that we've just seen?
I would assume it must be, because there's no other statement in the appeal bundles. So here the appellant gives, in essence, the same account as that had been given in that letter. in essence, that he knew he was entitled to an exemption by law. He had a martyr certificate. In fact, he went on to produce that martyr certificate, and the court has that certificate, pages 302 to 304 of the bundle. They were before the First-tier Tribunal. And that comes with a certificate naming this appellant particularly and confirming that he is a relative of his father. So those documents are the critical documents which the Upper Tribunal judge finds that First-tier didn't engage with adequately.
Where do we find the certificate?
Yes, my lord, it's 302. That is the English translation, certified translation. 304 is the original Vietnamese martyr certificate for the appellant's father. And then 305 is the original certificate naming the appellant as a relative. And 306 is the English translation of that. But as I've already described the claim, this was not a claim. This was a claim focused on a fear of corrupt or rogue officials who were not carrying out what should have been carried out under Vietnamese law, but were in essence extorting him and forcing him to pay money. That was the fundamental premise of the case, was that I have a martyr certificate, but I was not able to obtain any exemption as a result.
Well, he was exempt on two bases, wasn't he? One, he was a student, and two, he had a martyr certificate.
When he was first presented with the call-up order in 2010, he refused for two reasons. And as the court will go on to see, the refusal letter points out that those are two alternative exemptions. That you can claim an exemption if you're still studying, or alternatively if you have a martyr certificate. But at that stage, 2010, he was still studying, so he raised both of them with the recruiters, and neither of the exemptions bore fruit, because we say this was a corrupt official who didn't care and simply wanted to extort money, regardless of the position under Vietnamese law.
And then he says he's stabbed in Ho Chi Minh City. And the medical certificate, though, refers to the rupture of the ACL, doesn't it?
The medical certificate.
Page 300, but makes no mention of the stab. Or is that wrong?
I believe there are two. So at page 294. Under section 3 of the
Which page?
294.
294.
It's slightly more legible in the hard copy that you very kindly gave us.
I'm just looking where it says disease process. It says while riding a bicycle on the road, the patient injured his right leg and could not stand up. Limited movement of the right knee joint.
His case was that he was stabbed in the leg and then had to go to the hospital. Was that or not?
He was beaten, yes, and stabbed, but that he didn't say that.
No, he said he'd been involved in a road traffic accident. But the medical notes don't actually say any stabbing, do they?
It just says injured his right leg.
Reason for hospitalisation, right knee pain, medical records, injured right leg, could not stand up, limited movement of the joint.
And just so that you understand fairly, I mean, as I understood it from the Upper Tribunal, although the reasons weren't fully developed, one of their complaints is that it's sort of odd that this isn't chased down in the reasoning.
And just to finish off on this document actually says, initial diagnosis, as my lord pointed out earlier, monitor for ACL rupture and cartilage damage, treatment, Zimmer brace. So you wouldn't be treating a stab wound, or indeed any kind of wound of that nature, with a brace.
What I perhaps the court hasn't seen is page 291. Which relates to the so to be clear, there were two incidents when this appellant went to the hospital. This one is
Oh, I see, right.
from November the 10th, 2016 to November the 17th, 2016. And this describes the initial diagnosis at the bottom of page 291, a 1.5 centimetre wound on the lower third of the outer thigh, and treatment, wound dressing. I'm grateful to my learned friend. In one pathological process, maybe there are lots of ones and twos, almost halfway down each pathological process. Attacked by a sharp object, suspected knife in the thigh.
Yep.
Of course, I'm always ready to be taken on a course that I didn't plan or particularly want to go. But my reading of the Upper Tribunal decision is that the error was confined to the use of the martyr certificate.
The appellant gave evidence in the First-tier Tribunal, did he?
Yes.
Was he challenged about the proposition he'd been stabbed?
My lord, we don't have a record of the cross-examination, but I might suggest it's surprising if the Secretary of State's case is we don't believe what you say, you don't accept these medical records, then it certainly should have been put in.
I think the First-tier Tribunal judge just said something like, there's a record of the evidence and that stands as a record, but of course we don't get that.
The first, yes, and I do apologise for not having.
No, don't worry. We know how these things work.
These days it is slightly easier because all the tribunal hearings are recorded.
Yeah.
But they still need to be written up.
So there are two dates, 9th of November and 10th of December, is that right?
Yes. And it's after the second occasion that the appellant is asked to double the amount he pays and then decides to leave permanently.
So after the second...
After the second attack in 2016.
So the December attack, is that right?
Yes, ma'am. by the Secretary of State in submissions to the First-tier Tribunal was that the hospital could have been expected to identify the deficiencies with the appellant's explanation for what had happened and reported this as a stabbing. As that's in this country, medical practitioners are lied to, in which case the police are contacted. The First-tier Tribunal rejects that analysis and finds that it's reasonably plausible that the hospital staff would not question the appellant on this and would have no reason to. As I said, I am, I hope, prepared to be taken, of course, but I would be resistant to new deficiencies being identified in the First-tier Tribunal's decision outside of the realms of what the Upper Tribunal has found.
Can I? You said it was after the second one he decided to leave. Do you mind just going back to 378 and his letter? I got where he's saying this time was so bad they even stabbed my leg. After I recovered, I went back to work on the ship and decided not to come back. But it seems that there are 2 hospital admissions then.
Yes, my lord. There are 2 sets of medical records from November and December.
And does he explain how they're related, either here or in his statement?
I'm just checking the asylum interview record.
The asylum interview is
392.
92. Yeah.
So over the page on 393 describes how in November 2016 he got beaten up in Ho Chi Minh City, away from his home area, where he was beaten and struck with a knife in the leg. And then final paragraph, I didn't pay the money, and got beaten again in December 2016 by the same people. And that's when he went to the hospital and said he'd fallen off by road traffic accident. And after recovering from that, he, in April 2017, left Vietnam.
Thank you.
The next document important to the court's analysis is, of course, the decision by the Secretary of State, which the court has from page, substantive reasoning from page 6. There are a great many matters which I can fast forward through because they don't bear upon the issues before this court.
Sorry, the page number again?
Starts from page 6 of the appeal bundle.
Thank you.
It's a deportation decision, but the right of appeal lay only in respect of the refusal of the protection and human rights claims, and that was a statutory appeal under section 82, 82(1)(a) of the Nationality, Immigration and Asylum Act of 2002. From page 12, the Secretary of State, the decision maker, accurately, 10 at the bottom describes the letter, then records the Rule 35 report, which is a compulsory report when the appellant is detained, and then describes the asylum interview and summarises it accurately, and then deals with the claim itself, credibility of the claim under material facts consideration on page 14 of the appeal bundle. The decision maker then relies on an excerpt from Country of Origin Information Report from 2013, setting out the legal provisions related to avoidance of service, and also, perhaps of relevance, though it hasn't been mentioned, is Article 261, on page 15 of the appeal bundle, towards the bottom, which would appear to say that those who abuse positions and all powers to act against the regulations on military service registration, they're guilty of a crime, in essence. Article 259 above is the provision relating to evading military service. Although it's not contained within this excerpt or within the section, apparently, the Secretary of State, the decision maker, goes on to explain that actually there are exemptions to that, or defences, I describe them as we've referred to, when your person's in education, or when a person is exempt because of having a family member who's been martyred, on page 16. The Secretary of State's essential point, if this had simply been a mistake, then you could have rectified the situation with the martyr certificate. And if they had tried to punish you, then you would have been judged under the penal code. You said that, well, you showed them the certificate, but they still arrested you. So we say there must have been a proper channel for you to lodge a complaint. And then a separate criticism is made, failure to provide corroborative evidence, reasonably available corroborative evidence, according to the decision maker. Then, thirdly, the point which I have referred to already, that the medical staff in the hospital ought to have known the difference between a traffic accident and an assault. It's not plausible that they would have accepted your explanation. Then the Section 8 factors are dealt with under the heading Section 8 consideration. We can then go to the First-tier Tribunal's decision, on page 26 of the appeal bundle. I've attempted to summarise that in some detail in my written skeleton argument, paragraph by paragraph. So I don't want to, having already taken the court through the background to the ground at some length, I don't want to repeat anything which you don't have to, or which the court can't take from my written submissions. I only want to highlight the relevant parts from paragraph paragraph 26 on page 31 is where the First-tier Tribunal Judge deals with findings relating to credibility, findings of fact. Starts by observing that she'd taken account of everything that she'd heard and all the evidence referred to by the parties, and having considered it in the round, she'd applied well-established authorities explaining how to apply the lower standard of proof. Paragraph 27, she notes and she proceeds on the basis of undisputed facts, which were that a 21-year-old man would be obliged to undergo military service in Vietnam unless he had a relevant exemption, and that that person would be imprisoned for draft evasion. And secondly, that relying on the website reference in the decision letter, that children of martyrs were exempted from conscription. And of course, this is also what the appellant says. Let me say that from the start. There is then the judge's substantive analysis of credibility, and there is no set or required way for first instance tribunal in an appellate appeal to structure findings. But what this judge decides to do, consider it makes sense, is to separate the matters into factors which don't damage the appellant's credibility. That is, the submissions made to her by the respondent or by the Secretary of State, why credibility was damaged, which she didn't accept. Then from paragraph 36 to list the factors that did cause her concern in respect of credibility. And then finally at 44 to come to a reasonable conclusion, applying the lower standard. I would at the outset submit that that is a sensible way to approach the task of fact finding, you can call it that, in an asylum appeal, because it ensures that the First-tier Tribunal deals with all the submissions made by the Secretary of State, and it provides a coherent structure for which a reader can understand. I say that because, of course, the Tribunal is going to go on to find that this was problematic. But at paragraph 44, I say that that is the meat of this First-tier Tribunal's decision, ultimately, having taken all those matters into account. Ultimately, I don't find his account implausible, and I find it a good level of internal consistency, and for that reason I'm satisfied that to the lower standard there is a reasonable possibility or a real risk that this occurred as claimed. Now, there may be cause to come back to analyse particular passages, certainly paragraphs 29 through to 32.
Just on 32, because it's obviously central to the Upper Tribunal's decision. I mean, the judge says, and the judge heard the evidence, well, I accept the lower standard that you didn't try and claim in the courts where you were, because you knew who the people were and they were well connected locally. But that doesn't deal with the issue of what happens in Ho Chi Minh, where there are courts and there is, as the judge finds, and that's based soundly on the country guidance and where that is a different point. That there is due process in Vietnam.
Well, that is at the heart of this appeal.
Yeah.
And I'm going to submit, in essence, that the judge, first-tier judge, had well in mind the submission that he could have obtained due process if he had sought it outside of channels. That was the Secretary of State's primary submission. But the judge also found that he had sought to raise complaints. He'd written letters, but that had not stopped these corrupt officials locating him and harming him. And the first-tier judge also found that these individuals had tortured him 3 times. And so that is an answer to why he didn't do any more. And I'm going to submit that one steps back a moment and considers this man's position as someone in his 20s. He's being asked effectively to take on or risk further harm by trying to obtain or trying to do more, and I'm going to submit that it is inherently plausible that someone would not take that risk, and that is, from the findings the First-tier Tribunal judge makes, that is clear.
Does the First-tier Tribunal judge deal with that in the findings? Because, I mean, that's really the other criticism of the Upper Tribunal judge, which is no reasons. You've not actually said that. You say it can be inferred, which we'll obviously have to consider.
The judge is considering the appellant's account of events, first in 2010 and then in 2016. Having found as fact that he did try in 2016 to raise a complaint against these individuals, that led to him being beaten up again twice. I submit that that is effectively sufficient to address this idea that it's implausible that he would have not done more. The judge was well aware that that was the submission of the Secretary of State, but if the judge accepts the appellant's factual account as reasonably plausible, then that is addressing the submission that that was implausible. And bearing in mind that the judge at the forefront of her consideration notes that he had a right to an exemption, it would be certainly very surprising if the First-tier Tribunal didn't have that in mind when assessing the narrative. In essence, he didn't seek to complain further because he was scared of what was going to happen to him because of what had already happened to him. And I'm going to submit that it is sufficiently clear in a reasoning challenge from all the findings taken together, read as a whole, that the judge found it reasonably plausible that the appellant didn't go and try and have his day in court, as it's put. So I will return quickly that I wanted very briefly to address you on the law, which is not disputed. But I wanted in particular, and hopefully briefly, to take you through some of the passages of MAH Egypt, which deals with the standard of proof. The court should have that authority behind tab 15 of the authorities bundle. And my plan is to take people only to the passages where Justice Singh sets out the relevant legal terms from paragraph 48. Paragraph 51, Justice Singh makes an observation that, strictly speaking, it's not entirely accurate to refer to the lower standard as a standard of proof, because the applicant doesn't have to prove anything. More accurately described as an assessment of risk.
So which paragraph are you on?
51.
Thank you.
Paragraph 53, Justice Singh contrasts this exercise to the familiar one in ordinary civil litigation, and cites dictum of Lord Justice Brooke in Karanakaran, which the court also has behind tab 2. And I emphasise only one part, that is, in the passage cited from that judgment, paragraph 3, a first-tier tribunal in this appeal is entitled to take into account evidence to which they're willing to attach some credence, even if they couldn't go so far as to say it's probably true. And perhaps the same point, paragraph 56, cites further Lord Justice Brooke's judgment to say it's wrong to exclude matters simply because the decision maker believes that they probably didn't occur.
The judge actually found this wasn't an asylum claim, though.
Yes, but my submission is the lower standard of proof applies equally to humanitarian protection appeals, as it does to appeals under Article 3.
And understood, but have you the authority for that? Because this is specifically on asylum claims.
Regret, I would have to go away and find that.
Yeah, I don't think it's controversial, but this isn't helpful on this particular appeal.
I'm grateful. I certainly will try to find that. As my lord said, it's not controversial, so I don't have it at the top
But
of my...
it's because you've got the question is real risk. But there are, I mean, just so that you know, there are a number of authorities, particularly in extradition matters, where people have made findings effectively on civil balance probabilities about what treatment has taken place to a person without necessarily doing that before then turning to issues of real risk. So real risk may be, because it's future looking, different, but is it right to apply to the findings on the way?
Yes, Article 3 is formulated as substantial grounds for believing.
Yeah.
I will hopefully find authority.
Yeah, thank you.
As someone who appears fairly routinely in the immigration tribunals, it's normally taken as read that the same standard applies under humanitarian protection, which, strictly speaking, is Article 15b of the directive.
Yeah.
Serious harm. But I say that this analysis is equally applicable in the context with which we're concerned. And the only other part of authority I wanted to take the court to was a citation of Lord Justice Green's dictum in the case of SV Sri Lanka, which can find at paragraph 59 of Lord Justice Singh's judgment in MAH. And I cite that simply to observe that the matters which first instance tribunal is entitled to consider include the consistency or otherwise of accounts given to investigators at different points in time, the consistency of the narrative with a person's actual conduct, and finally the last point, the overall plausibility of an appellant's account. And the reason I take the court to those passages is because I'm going to submit that paragraph 44 of the First-tier Tribunal's decision is sufficient to explain the judge's reasoning on credibility, because in a lower standard case, the first instance judge is entitled to rely on issues such as consistency or plausibility. And indeed, in many cases, those may be the only indicators, and that we are certainly not dealing with the familiar task, which I dare say members of this court will have much more familiarity with, applying the civil standard of proof. And I'm also going to submit that if that is right, then when it comes to a reasoning challenge, then there ought to be, in my submission, a correspondingly lower threshold to justify a decision. In other words, a decision which might not meet the adequacy of reasons test in a balance of probabilities assessment does not mean that it doesn't meet the reasoning standard required in a lower standard case.
Is there any authority for that proposition?
Not one that I have found.
And could you just deal with this proposition? I mean, asylum is vital, but it's also vital that it's not misused. The Secretary of State is entitled to know when findings of fact are made or not made in her favour. Why wouldn't that apply in an asylum case?
Absolutely, and I don't do that to say a judge doesn't need to reason their findings. Of course not. But when we are looking at forensic analysis of a First-tier Tribunal decision, I submit there is more leeway to a first-tier judge when the task they have to consider is there a chance, a realistic possibility that this happened, rather than did this more likely than not happen.
Well, speaking for myself, I'm afraid I don't really understand that. It's obviously a lower standard that has to be attained. But if it's insufficient to say, well, I just think that's more probable, why is it sufficient to say, well, I just think that's plausible? Surely, whether it's plausibility or balance of probabilities or even proof beyond a reasonable doubt, if there's a requirement to give reasons, do they not have to be reasons to explain why the requisite standard has been attained?
My lord, I agree. I don't push the point too far. Okay. But I think it is still important to remind ourselves that this judge is applying the lower standard of proof.
Yes, of course. Yeah.
And I say that more for the criticism that is going to be made that in structuring her decision and in weighing up, which is the word that she uses, it is easy to treat this as if she is applying a civil standard, because she's sort of dealing with the issues that weigh against and the issues that weigh in favour, and weighing them all together. Also, she says that ultimately that's not the task she was required to perform. Her task was simply, is there a reasonable degree of likelihood that this happened? And so simply a finding that someone is given a consistent account which is not implausible is reasoning enough next, I don't need to do this long, but the next category under which we've put in some authorities is the approach of an appellate court. And there are several cases essentially all saying very similar, if not the same thing. And I take just two of them, and I choose the two which were referred to by the Upper Tribunal. There is no dispute again. Volpe and Volpe behind tab 13. And case of T. Both were again civil standard cases. But the general principles apply. And because I think, dealing with a reasoning challenge, I just stop and note paragraph 2, subsection Roman numeral 6, dealing with the reasons.
Which page are we on, please?
Forgive me, this is paragraph 2 of Volpe, which should have behind tab 13 the authorities bundle.
Can you give me a page, please?
The authorities bundle is not numbered.
In the electronic copy, it's
Forgive me, 240.
240.
Yes, forgive me, not in the paper. That is the paragraph 2 to which this court would have been referred many times, I imagine. But I only stop at Roman numeral 6, just dealing with reasons. Effectively reminding appellate courts that reasons will always be capable of having been better expressed, and narrow textual analysis should be avoided. This is not a piece of legislation or contract. In other words, one has to look at the entirety of the reasoning process in the determination, and not hone in on particular sentences or paragraphs unduly. That is the same proposition in essence as set out in several of the other authorities, which I hope I can accurately summarise as a reasoning challenge has to meet the threshold of enabling the parties or the appeal court to understand the basis on which the decision was reached, not the highest threshold, simply can the parties understand. And finally, in T, which I don't think has been reported, so we have the transcript behind tab 16. Paragraph 56. Is where the court deals with the principles of law and cites well-known passages from previous judgments, in particular Volpe and Volpe, as we've looked at, but also Page, UK Limited, and Shabani, both judgments of Lord Justice Lewison. And this, I really don't need to, but I highlight Roman numeral 4. We've already dealt with most of the principles, but the well-cited, well-rehearsed expression that the judge will have to regard in first instance to the whole sea of evidence rather than island hopping. And I will submit that it's important to remember that this first-tier tribunal had regard to all the evidence before, and it says so. court is faced with a question, can it be inferred from her determination that she had well in mind this issue of the appellant's eligibility for an exemption? And I'm going to submit that this court can say with sufficient certainty that she had, because it features throughout not only the appellant's case as argued, but also her determination, where she starts off by saying he was eligible for it. So having done that, I can hopefully be fairly quick through my submission.
Can I, just before you leave the factual basis, when he left the ship, that was because his contract had terminated early. Do we know anything more than that? Because he was reported, in fact, as having jumped ship rather than...
Yes, he was listed as a seaman deserter.
Yes, which doesn't seem to be a contract terminating early, unless one's being very legal in an approach.
I hadn't had cause to investigate that because it wasn't raised as an issue. I'm more than happy to check through everything to see.
Yeah, well, I've looked and couldn't see it. I just wondered. Yeah.
Sure, my lord is right. If there is anything relevant I can return to, I shall endeavour to find it. His case, I think, yes, was my contract ended.
Well, that was his reason for staying in the UK and not staying on the ship to Germany. And he said, because my contract ended early. But on the face of it, he left the ship. So it is true his contract ended early, but because he got off.
Well,
I just couldn't chase that down, as it were.
The information, my understanding is that it's the Secretary of State who issued a notice labelling him as a seaman deserter. And the court has that notice. Page 348. Page 351.
351.
And in additional information, it certainly does suggest that he'd not returned to the ship.
Left all his belongings in his cabin.
That's what this records. I'm not clear. Where this information came from. That, of course, would have been relevant to the Section 8.
Yes, although, as you fairly point out, the First-tier Tribunal Judge has referred back to those paragraphs when dealing with the assessment of credibility, because it doesn't exclude that.
In terms of the Section 8 consideration.
Yeah, I mean, the paragraph you took us to, which I think was 44 or 43. 44, yeah. There are matters that raise serious concerns about the appellant's credibility, for example, as referred to in 37 to 43 above. But actually, 39 to 42 is all, or 43 is all about Section 8. And the district judge says, paragraph 41, the appellant says he originally wanted to settle in Germany. His contract ended early before the ship reached Germany, which just struck me as difficult to follow with the papers.
I would submit this would have been dealt with in the evidence in terms of the document that we've just looked at, the seaman deserter record, is not necessarily inconsistent with an understanding by an appellant that his contract was to be terminated. And I would submit this court should be careful in looking at matters which were not eventually relied upon by the...
I understand that, but if the whole gist of the Secretary of State's appeal, badly expressed as you rightly point out, to the Upper Tribunal is, look, the judge has just not grappled with this, then aren't these just practical illustrations of these points?
I don't accept that it's permissible for the Secretary of State's grounds to be treated as an open invitation for the Upper Tribunal, still less this court, to find evidence which were not already found by the Upper Tribunal. And that is why I started by taking this court through the parameters.
Yep.
And
well, that's why I wanted to raise it specifically, because it was before you left the facts, because it was the only other bit that I couldn't chase down.
There may be other matters, and I'm not saying that the court is obviously a higher court and may well see matters that could have been grounds for further complaint. But I would submit that insofar as the task of this court is concerned, in this appeal, namely, did the first-tier judge err in the ways set out by the Upper Tribunal, unless the Secretary of State, by way of a respondent's notice, was to try and argue that the first-tier judge had erred in different ways, I would try and be a bit resistant to a suggestion, or to the court even having it in its mind.
Yeah.
Ultimately, I think my response would also be that in a lower standard case where potentially a 10% chance of this happening is sufficient, then matters such as the one we've just been discussing are certainly not, certainly not a smoking gun, which sort of means that there's no doubt that it didn't.
Thank you. Sorry to interrupt, but it was just chasing it down before we left the facts.
So my three preliminary observations, as I've already made two, in fact I think I've made all of them.
Well, you said there were two, and you've made two. So.
The third one is just related to the standard of proof and the discussion that my lord we had in relation to the reasoning. And what I wasn't suggesting is that there is no duty for a first-tier tribunal to explain, but that it is important to bear in mind throughout that we are dealing with a lower standard of proof. I just wanted to double check that I had addressed you on all of those. So I've emphasised again, this is from paragraph 33 of my skeleton argument, we're not dealing with perversity. And that, I think I can make the same submission as I just made to my lord.
Well, that's obviously right, but I'm not quite sure where that gets us, because if the finding had been perverse, it would have been reversed by the Upper Tribunal. But the Upper Tribunal didn't reverse. It set aside and remitted.
I would be careful in what I say in response to that, because my experience is that finding perversity in in an upper tribunal decision does not always mean the upper tribunal would remake the decision.
No, I can see it doesn't inevitably lead to that outcome, but
I can see
one would have thought it would usually lead to that outcome.
I understand the point, of course. No reasonable judge could find. Then why send it back? But I say this because I'm going to submit that the reasoning for an error of law is important, and
Yeah, well, as you pointed out, the ground was straightforward. It was adequacy of reasons. It wasn't perversity.
I also said that just because in my learned friend's skeleton argument there was a suggestion that perverse findings haven't been made.
Sorry, there was a suggestion.
Suggestion that there were perverse findings that the upper tribunal had found as such, and so I wanted to correct that. The second observation, which was the past account and future risk distinction, I've made really because of some of the comments, not just in the sexual state skeleton argument, but also in the upper tribunal's decision, which I say betray a sort of elision to concepts. And I refer in particular to paragraph 68 of the Upper Tribunal's decision for that point, which should be able to find at page 68 of the appeal bundle. This is where the Upper Tribunal is describing the martyr's certificate. And describes it in the way that this shows that there was objectively no real risk. And there had never been such a risk. And together with the submissions I've taken you to in the skeleton argument and the grounds that sufficiency protection is available, it might be said that the Upper Tribunal had in mind the issue of sufficiency of protection. Oh, this appellant could go home and have his day in court. That's why I've sought to emphasise that that's not the task. The First-tier Tribunal was required to perform simply assessing the likelihood or the plausibility of what the appellant had said happened in the past. There being no dispute that he ought to have been able to be entitled to an exemption.
As you've taken us to 68, can I just ask you about 67, which was, I mean, I think it does pick up the point about it's a very odd bit just before paragraph 44 when there is that passage saying, I've taken into account all these matters damaging the credibility, but on the face of it, in section 8, the judge hasn't actually found anything damaging credibility, as it expressly said, well, section 8 doesn't apply.
That's not quite accurate. Forgive me, my lord. The judge says that she was prepared to attach relatively little weight to the section 8 factors. I mean, maybe a nuance,
but in that paragraph is the bit about the sort of departure from the ship. So perhaps the first-tier tribunal judge had actually worked out that the reasoning was poor and then says it was damaging. But is that really is that properly explained?
So the actual error that we're dealing with is that it's incoherent.
Yeah.
The judge had referred to this factor as one of serious concern. When, as the court has seen, there was a direct challenge to the judge's consideration at 39 and 42 of section 8,
Yeah.
which was not accepted
No, the Upper Tribunal rejected that.
It's merely, we're concerned only with whether it makes sense that the first-tier judge referred to it together with the other two matters which she said counted against her. And my submission, as you will have seen already, is going to be that this was just a sensible way of grouping together the factors. First, that she didn't accept damaged credibility, and then secondly, those that she did accept credibility, and that both the permission judge and the Upper Tribunal have jumped on this word serious concern as saying, well, if there's serious concerns, then how does your rest of your reasoning justify it? Whereas if one actually looks at the substance of the reasoning, which was not successfully challenged, it is apparent that there was relatively little weight attached to it. So if there is a slip by the First-tier Tribunal, it's simply in describing that as a matter of serious concern. But my response is that it is sufficiently clear, reading her decision as a whole, that she didn't attach or have a serious concern about that delay. And it's just the way that she's decided to structure her findings. I was going to return to that, but I wanted to deal first with the martyr certificate issue, because of course that's, in some respects, the heart of the case. Although I will tentatively suggest that the Upper Tribunal has perhaps sought to add other matters to reinforce a complaint which I say is not particularly strong on its own. So I've been careful to separate them out at risk of throwing all the mud together and saying, well, there's enough there. So my submissions on this are from 41 of my skeleton argument. I don't plan to repeat what I've said, but I do submit that the reasoning is not, of the Upper Tribunal, is not very well expressed, and I have sympathy perhaps because of the history of the way that the grounds were formulated and argued. But certainly the summary that the Upper Tribunal judge makes of his own reasoning at 69 is problematic, I submit.
Well, isn't this a very straightforward point? The point that the Upper Tribunal made is that when you look at paragraph 44, there is no mention of the martyr certificate anywhere in that paragraph at all. It's as simple as that, isn't it?
In terms of it being a failure of reasoning.
Yes. Because it's not mentioned at all, it follows that no reasons are given in relation to it in paragraph 44. And that must be right, mustn't it?
Well, it's right that it's not mentioned at paragraph 44, but paragraph 44 is the concluding paragraph of all the findings that the judge has made up to that point. It's in effect weighing together all the findings she's already made. And it's not arguable, in my respectful submission, that the First-tier Tribunal did not consider the martyr certificate or have regard to it.
No, but there's a difference there, isn't there? I quite understand you say it's obvious that she was aware of the martyr certificate and took it into account elsewhere in the decision. That's obviously right, because she says so in terms. But that's not the point. The point is that when you get to 44, which is where she's setting out her reasons for her conclusion, it's not even mentioned, and therefore no reasons are given.
But 44 also doesn't mention anything else, except any of the other matters which had been dealt with in the preceding passages either. 44, it has to be read together with all those paragraphs. And if this court is prepared to accept my submission or my observation that the relevance of that certificate was purely in terms of plausibility, then the way the First-tier Tribunal dealt with it in the preceding paragraphs is sufficient if this is a reasoning challenge. In essence, the judge did not have to refer to it again in paragraph 44 as suggested by the Upper she had already dealt with it when examining the plausibility of what this appellant said had happened to him, which was the key issue.
Can I just ask on that particular point? As we know, the judge says 37 to 43 are the issues that seriously damage the appellant's credibility. If one looks at that, and this picks up another point which I know you're coming to, there is no mention there of the martyr's certificate, nor of the conviction, and in fact lie when he was arrested, which you might have thought would also be damaging to his credibility.
The conviction.
Well, the fact that he was running a cannabis farm, diverting electricity, and when stopped by the police said, gave a false name.
So that dishonesty.
Yeah.
In respect.
Because if you're capable of lying when arrested and finally freed from whatever the situation was, then that also goes into credibility, doesn't it?
It could have been relied upon by the Secretary of State as something relevant to credibility. I accept that, but perhaps of limited value.
Well,
People lie about hiding a crime. Doesn't mean they're lying about other matters. But certainly being convicted of a crime, unless it's
well, there was also the dishonesty in diverting the electricity. Anyway,
a conviction.
but because the only reason I say it is because looking at the submissions made below, that was described as the elephant in the room, in a sort of slightly grandiose way. Submissions before the Upper Tribunal.
That was again related to the Section 8 challenge. Which the Upper Tribunal dealt with in paragraph 56 to 58. So the elephant in the room is referred to in paragraph 56. But the judge accepts that, the Upper Tribunal judge accepts that the first-tier judge didn't expressly take into account the appellant's involvement in a criminal enterprise. However, the first-tier judge was not bound to rehearse every argument as to why the appellant's explanation should be disbelieved. And ultimately, this error of law challenges an expression of disagreement with a finding that was reasonably open to the first-tier judge for the reasons which he gave. That's a degree of irony that I'm saying the same thing about the first-tier judge's treatment of a different issue. But I am still going to try and be a bit robust in insisting that this court stick to the breadth of the issues is formulated by the Upper Tribunal. And while it is right that in principle evidence of dishonesty can be relevant to someone's credibility, that would be a submission that has to have been made before the First-tier Tribunal. And we are dealing with a First-tier Tribunal's decision which cannot be impugned on the basis of something that was never argued or should be expected to be considered. Namely, you've previously been dishonest, so that's a negative indicator. That was a point made in the grounds, in the skeleton argument for the Upper Tribunal. And the Upper Tribunal found that, well, obviously she considered it because she had to deal with the Section 72 issue, so she can't have not had it in mind. And I'm going to make the same point in respect of the martyr certificate. Obviously she considered it in respect of accepting that he was eligible for an exemption, and in dealing with the events in the narrative that Appellant had given, that you can't assume that she therefore blocked it out. It makes no sense to say that she would have. She clearly would have had it in mind. So turning to the describing this as an intelligent or an error of reasoning, the judge approach to this exemption in the martyr certificate. I'm going to return again to First-tier Tribunal determination, paragraph 29. Page 32 of the appeal bundle. The judge records paragraph 54 of the decision, which we've looked at, the actual submission which we're looking at. If the Vietnamese recruitment office had made a mistake, then you could have easily rectified it by providing your late father's martyr certificate. So the judge clearly has that submission in mind and deals with it, and records that the appellant doesn't dispute that that's what the law says. But his explanation is that I didn't because I knew that the person who had beaten me, or who was in charge, was related to the head of police. So I didn't expect I would have any luck. And the judge finds that that is reasonably plausible, because this is an abuse of power, not someone who is applying the law. Then again, at paragraph 32, the first-tier judge records the very submission the Upper Tribunal goes on to rely on, which is there must be a proper channel for the appellant to lodge a complaint. It would have to be considered under the law, and that he hadn't attempted to seek any protection from those who detained him. The judge, again, deals with the point in the context of why he hadn't done in 2010, and finds his evidence reasonably plausible. The judge does refer to the fact that the appellant actually named these individuals, and the respondent didn't challenge him on that. But this is a judge that heard the appellant give evidence on the point, and I submit was entitled to find that that was reasonably plausible, applying the lower standard of proof. The judge then deals with matters the Secretary of State relied upon, and particularly 35, the appellant says that after he was detained and beaten in 2016, after writing complaints, that he was beaten again, and detained and beaten again. So it's clear that the judge had well in mind the fact that he had a martyr certificate, the fact that due process exists, and dealt with all the submissions which are now being suggested that she didn't deal with adequately. And as I touched on before, I submit that it's not just intelligible, this decision. There is a degree of it being fairly persuasive, because you have someone who, in their mid-20s, has been beaten up and tortured by uniformed, albeit rogue, agents. And after a few years, his reason in 2010 for not initially seeking it is accepted as reasonably plausible. He then, when he writes complaints in 2016, suffers the consequences of being beaten up again twice. I submit that it is reasonably plausible that this young man wouldn't have thought to have his day in court. In essence, it's asking too much of him. He knew he was entitled to an exemption, but the question is whether he sought it. And the judge found that it was reasonably plausible that he didn't. And having found findings on all the other matters, that was a finding that I say adequately explained her reasoning. I say that if the judge didn't misdirect herself in law, applied the correct standard of proof, took into account the matters that were relevant to her decision on credibility, and gave intelligible reasons why the appellant was not found to be incredible, then that meets the minimum level of reasoning and there is no error of law. Even if this court or another court might come to a different conclusion. I end by addressing the last two matters which the Upper Tribunal relied upon. And these are expressed as the two matters at paragraphs 66 and 67, which are described as highly problematic. The first that we've alluded to, so I can be brief, the judge suggests that it's an internal inconsistency. The judge
Sorry, can you just give me a page reference?
Oh, forgive me. It's page 68 of the main bundle. So, paragraph 65, the Upper Tribunal judge criticises paragraph 44
Yes.
and describes the balancing exercise, which is not the best. It is what, on the face of it, the judge is doing, but it's not a balancing exercise in the traditional way we understand it. But the first two matters which were problematic are first the inconsistency between the way the judge describes the Section 8 factor in 44 with the way that she had just dealt with them in the preceding four paragraphs. I say that is not an error of law. If one actually reads the four paragraphs before, it's obvious that the First-tier Tribunal judge attaches relatively little weight. And I say she simply grouped them together with matters of concern which she may have slipped by saying serious concern because she's already found that relatively little weight. But that if the Secretary of State is saying, I don't understand this, then all the Secretary of State has to do is go back and look at the preceding paragraphs and it's clear what the judge has actually found in respect of the Section 8 matters.
Well, can I just ask you to deal with this point? I entirely agree with that, but that only works if you do substitute for serious slight, because otherwise isn't the criticism valid, which is, okay, so there are these serious criticisms of credibility and nothing to set against it.
Well, I would first submit that the judge doesn't have to set anything against it because this is a lower standard
Yeah.
proof case. And that's maybe the point I was trying to make unsuccessfully, which is that the judge still has to reason findings, but I think she almost created this issue by using the word outweigh and by structuring it in this way. And I think the only change might be is just to remove the word serious in terms of she's grouped together the matters of concern. She's grouped together the matters which don't cause concern. And that's, she's simply saying, well, I take into account the matters of concern, but ultimately I find this is a consistent account and a plausible account, and I accept it to the lower standard. So the reasoning is in 44. It's the consistency and the fact that it's not implausible. And that, taking back to the MAH Egypt case, and the dictum of Lord Justice Green, these are matters which a judge is entitled in a lower standard put weight on and are sufficient to outweigh the concern.
Thank you.
The second complaint, paragraph 67, is related because the Upper Tribunal judge reads this as her weighing up the matters which she said don't cause me concern as positive, or matters which weigh in the balance in favour of the appellant. And then it's not clear whether they are simply defensive, more. I have two answers to that. My primary answer is the one I've just made, which is that in paragraph 44 it's sufficiently clear that the key elements which caused her to accept the claim on the lower standard were the consistency of the answers and the lack of enforceability. And of course, we know that this is a judge who had regard, heard the evidence, heard the appellant cross-examined, is entitled to attach significant weight to consistency of his answers. I also have suggested that actually it's not quite accurate to suggest that the factors described as ones which don't damage the credibility are incapable of performing the function of adding to credibility, because if the judge finds an account is not implausible, I submit that that is the same as finding it to be reasonably plausible, in which case it is a matter which, applying the guidance in lower standard cases, is capable of supporting or adding weight to an account.
Sorry, I missed that last submission because there was a wee bit of banging. You said if it's implausible.
So my point, I'm not sure at the point why I lost me, but I'll start.
Sorry.
It was simply to say that the matters which the judge says don't cause her to reject credibility, so the matters that precede the matters that she finds damaging, the judge in the Upper Tribunal says that they're not reasonably capable of performing the function of supporting the appellant's case.
Yeah.
And I've already answered and said, well, whether that's true or not, 44 answers this complaint. But in fact, I don't accept that they're not reasonably capable of supporting the case, because if something is not implausible or is found to be reasonably plausible, then that is something that the first instance judge is entitled to rely on.
Well, is your point simply this? If it is plausible, for example, that he was sought out, attacked and stabbed, that finding is something to be taken into account in deciding whether other features of his evidence are plausible or implausible.
Oh, absolutely.
Yeah. So it doesn't, you would say, it doesn't, as the Upper Tribunal judge said, simply become a nothing point. It becomes a point in the appellant's favour. May not carry a huge amount of weight, but it's a point in his favour.
Absolutely, better expressed. That, my final point there is perhaps that might be an example which, in a civil standard case, may not be the same. I don't need to make that submission, but certainly the submission I make is that finding of reasonable plausibility in the context of an asylum assessment, a lower standard assessment, is a matter of weight that a judge is entitled to rely on. Having done that, I come to the end, really, of my submissions, and I only wanted to stop by, I don't wish to ambush anybody, but I wanted to briefly make sure the court was aware of the changes that have been brought about, which don't apply to this appeal, but which would apply to any appeals brought after or claims
If they
made.
don't apply, why do we need to worry about them?
No, you don't. But I was merely going to say that this has changed. This lower standard approach has changed as a result of the Nationality and Borders Act 2022, which is now a balance of probabilities assessment.
Right.
And so this sort of issue in future, if it came before this court, would be different. First instance judges not.
Well, it might be similar in the sense that you get the upper tribunal permissibly or impermissibly changing findings of fact, albeit to a different standard, which, as you rightly point out, has changed. But that didn't make any difference to this assessment, did it?
No, because it didn't apply.
Yeah. Thank
In future, past events were assessed on the balance of probabilities as a result of statutory intervention. That's the only thing I wanted to say.
All right. Thank you very much indeed. Nothing else. No, thank you. Right, Mr. Keith.
My lords, I hope you've got my skeleton argument with the, which is in the bundle, and also I hope an updated version with the page numbers in it. Although I think actually that the version page numbers that I got is slightly different. But my submissions, my lord, are essentially set out in my skeleton argument that the Upper Tribunal judge was correct to identify errors in the first-tier tribunal judgment, which made the assessment of credibility so poorly reasoned that it required a reassessment. That's the decision the Upper Tribunal judge has made. The Upper Tribunal judge has not substituted any findings of their own. They're simply, as my Lord Justice Arnold put, one of the key factors is that the martyr certificate is not referred to at paragraph 44, and in my submission is not properly referred to in any exercise in the assessment of credibility. And as a result, that key document, one of the conclusions of the Upper Tribunal is that the failure to make a decision on that key document and its provenance or lack thereof was crucial to the assessment of credibility. And because that wasn't done or wasn't done explicitly, that is one of the key reasons why the first-tier tribunal judge was wrong in the assessment of credibility. But really, the Upper Tribunal judge sets out, and I have said that in my skeleton as well, but I don't want to read it out to you, but from 63 essentially through to 69, the reasons that the judge finds that the credibility assessment is wrongly made. I accept that a concession has been made in the first-tier tribunal. The only assessment to be made in this case was past conduct, and if past conduct was found to be credible, plausible, then that the appeal would succeed. I'm not going to resile from that concession given where I am today. But that concession didn't encompass the need to make an assessment of whether or not there was sufficiency of protection or not. That's still a factor that the first-tier tribunal judge had to tackle properly, and the upper tribunal said that she didn't. There's some, I don't want to go down the rabbit hole too far of the plausibility, not plausible, balance probabilities issue, but well, Leonard Friend's correct, the law is about to change, but the overall conclusion is whether QY's narrative was plausible, not about individual sections. In my submission, you don't add up each plausible context. You look at the whole thing in the round, deciding whether or not the circumstances are plausible, and therefore whether there is whether the individual is credible or not. I can point you towards some authorities to consider later, but I don't have to. But given the questions that were put forward, I thought it might be helpful just to highlight where those are outlined in the case law in terms of what the lower standard means, if the court is wishing to, or I can place that in writing a short note afterwards. But it's Tanvir Ahmed is the there's also, let me just find it, statement of.
Is this on the
It's not in the authorities bundle, my lord. So none
on
of
the
these-
humanitarian point?
Is it? Was it on the humanitarian point, my lord? I did look for a specific reference to that in the case, but I haven't found it immediately.
No.
But caseworkers are instructed to treat them all as the same. I think that the case of Cancaran says that is the way to proceed, but I couldn't find the right paragraph in it, and I haven't. And it is quite an old case, but.
Garan, which is in the bundle at Divider 4.
Is it? So.
Given that you've both certified that we need to read all these authorities, you should know that it's there.
Apologies, my lord.
Don't worry.
But in a protection claim, the same standard of proof
Yes,
applies.
I know that. It was just.
But I haven't got a specific.
You can't. You think it was somewhere in Tahir Ahmed or in Karana Garan? Yeah.
Yes.
Yeah. Okay. Well, thanks. And certainly the guidance is clear that
And
the
certainly
same
guidance is
standard
clear.
applies. Yeah.
And so, my submission is that the Upper Tier Tribunal Judge was perfectly entitled to look at the First-tier Tribunal Judge's decision and be unsure about all of the factors that were placed in the balancing exercise or the credibility assessment. Unfortunately, there's a conflation of language between a balancing exercise, which is usually an article 8 human rights course, and a credibility assessment, which isn't always a balancing exercise. But the judge has chosen to do that, and there's nothing necessarily wrong with that approach. And the judge criticises that in 3 ways, but starting at 65. Saying that that's a highly problematic decision, and then going on to cite at 66, firstly, the internal inconsistency in treating the Section 8 issue, that being the failure to claim asylum immediately on entry, as being of little weight, and then placing that in the same category as the matters that are problematic and of serious concern. You can't have, in my submission, you can't have both, and I think in my submission the Upper Tribunal Judge was right.
And what do you say to the point that was suggested that in fact what that really means is slight when you read back and look at the Section 8 point?
That might be the case, my lord. But we're then in the process of saying it's not a clear error in my submission. It's not such that this court could say, well, it definitely should have been slight rather than serious, and therefore we can substitute that language and carry on. That's why that's why the Upper Tribunal Judge was in part concerned about the whole assessment and wanted it to be remade with those sorts of that type of analysis. And so I say, unless it is a clear error of either typographical or phraseology in a particular legal test, such that this court is confident that can be substituted, that you must take what is in the First-tier Tribunal judgment as being what was meant to be in it. And that's what the Upper Tribunal Judge has done. It said that doesn't make sense. It doesn't make a clear reading or clear reasoning, and therefore that factor, along with the other factors, is such that this needs re-examining only on the issue of credibility. And then the Upper Tribunal Judge, again at 67, outlines the second problem that he has with the First-tier Tribunal Judge's judgment, namely that most of the issues cited in paragraphs 37 to 43 of the First-tier Tribunal judgment are defensive, as he puts it, rather than positive or negative assessments of credibility. So they were things that didn't cause a problem with credibility. And so therefore, on one reading, and this is where the Upper Tribunal Judge is struggling, on one reading, it is that the factors that don't impact the credibility of the appellant are neutral or defensive, and therefore there's nothing to therefore the negative ones must outweigh that. But the First-tier Tribunal Judge has, it seems, done a balancing exercise weighing what First-tier Tribunal Judge has described as factors that don't damage credibility against several factors that do damage credibility, and assess the appellant as credible, rather than saying there are a number of factors that I find the appellant to be truthful, and I find those in his favour, or I find those plausible, and therefore weighing those against the negative aspects, the dishonesty, the potentially the Section 8 or the other factors, I find that he is not a credible witness, or that he is a credible witness. But having not done that exercise, having put a list of neutral factors and then a list of negative factors.
But they're not a list of neutral factors. The proposition that he was hunted down and stabbed in the leg is a serious matter. Once the judge has found his account to be plausible, why is that not a point in his favour to weigh against other criticisms? Why is it not directly relevant to the central criticism that the judge didn't pay sufficient attention to the certificate, when the judge's finding was, yes, he had the certificate, yes, he knew that in law that ought to be sufficient, but for the reasons he's explained, he didn't feel able to exercise his right in law. And in making that conclusion, why can't she take into account, I'm accepting as plausible his account that he was beaten up on 3 occasions. I'm accepting as plausible his claim that every time his ship docked, they seemed to know where he was. Why are these conclusions simply to be relegated to a status of nothingness?
My Lord, of course, your Lordship is correct. Those factors, having been found to be plausible, form a basis of the credibility assessment and form factors that the judge can take into account in the appellant's favour. But the way in which the judgment is structured is not that, my Lord. And so we have and that's why the Upper Tribunal Judge has described them as defensive.
Yes,
in 37.
but forgive me interrupting you, but towards the end of paragraph 67, the Upper Tribunal Judge, having made his observation that they seem to have been treated as enhancing credibility, asserts, nor are they reasonably capable of performing that function. Why is that a correct statement of principle?
Well, my Lord, I suppose I would have to accept, my Lord, that some of those factors are capable.
So the Upper Tribunal Judge has adopted a fundamentally incorrect approach, hasn't he? Because he has criticised the judge below for giving some weight to factors which he says are not capable of carrying any weight.
And then, my Lord, yes, in part, then we're into an argument between the Upper Tribunal Judge and the First-tier Tribunal Judge as to what factors are more important than other factors, and the Upper Tribunal Judge trying to do a credibility assessment without hearing the appellant.
Well, this is why it's a reasons challenge and
Yes.
not a challenge to the conclusion.
Yes. And whilst the Upper Tribunal Judge, and that's ultimately it, is that the Upper Tribunal Judge says there are, particularly the martyrs certificate, there are these factors that should have been taken into account, should have been weighed in this balance, and they haven't been. And they might be positive in his favour, they might be negative in his favour, they might be crucial, they might not be crucial. But the Upper Tribunal Judge considered the martyr certificate was so important in terms of credibility assessment, and a credibility assessment in terms of the sufficiency of protection. Because that's the crux of it. It's not just whether he was telling the truth about whether he was attacked.
Yeah,
or not.
so
It's about whether he's telling.
absolutely. There's no dispute for either tribunal about the martyr certificate and its effect. And so far as due process under Vietnamese law is concerned, it's found there is due process, and therefore your submission is, well, that squarely raises the question of sufficiency of protection, and the Upper Tribunal Judge's view was that there'd be no adequate reasons given for rejecting that.
Precisely. Because there's no reasoning about. Well, there's no reasoning about sufficiency of protection.
Yeah.
There's reasoning about whether he was telling the truth or whether it's plausible, not whether he's telling the truth, but whether he had told a plausible narrative. But the question is whether, even with that narrative being the truth, had he in fact availed himself or attempted to avail himself of protection from the Vietnamese authorities. And that was the question that the First-tier Tribunal Judge didn't answer, and was required to.
What about Mr. Georget's point that, well, because of the way that a concession had been made at the first instance, repeated at the Upper Tribunal and therefore rightly not challenged by you today, it didn't need to be. All you were doing was backward looking.
But the concession, my lord, is not helpful to me today. I appreciate that.
Yeah.
But the backward-looking focus is twofold. It's firstly, are the events described by the appellant plausible? And the First-tier Tribunal Judge has found that they are. But secondly, even if they are plausible, did he actually attempt at any point to avail himself of protection from the Vietnamese authorities?
Well, we know he didn't, and the First-tier Tribunal Judge assessed his reasons for doing so, and found his account to be plausible. Well, if the concession is that if the finding of credibility in his favour is going to be dispositive, then it's dispositive, isn't it? Subject to the criticism that inadequate reasoning has been shown. But isn't it, with respect, too late now to start talking about sufficiency of protection? Save insofar as it may have a bearing on credibility.
Well, my lord, yes, but, and I suppose that's my point that I've been inelegantly making, is that they're intertwined. Is that without making an assessment of protection at the same time as making the bottle bank to be empty.
I don't think it's a commentary on your submissions, Mr. Keith.
May well be, but the intertwining of the decision on credibility and the sufficiency of protection is needed to be done together. And in my submission, that hasn't been, and that was the concern of the Upper Tribunal Judge.
Right, I understand that.
And as a result, the credibility assessment needed to be remade, taking those factors into account. If, having taken all those factors into account, the appellant is found to be credible, then he will succeed in his appeal, and if not, then probably not. But I don't want to see into the future.
It's nothing to the thing, but Mr. Georget, having raised it, is it common ground that if the appeal doesn't succeed and there is a hearing at the First-tier Tribunal, that the old law would apply to him?
That I'd have to check. I'm happy to say from my independent because I'm not sure there is a new test in place.
Yeah.
It may well be that it has retroactive effect to all appeals. I'm not sure. My independent will be able to tell me. I'd have to check.
Yeah.
It applies to all claims made after 28th of June 2022. So
His claim was made before.
Yes.
Yeah.
But the question whether the Secretary of State would be tied to her concession is another matter.
No, I understand that.
I mean,
Thank you.
Before I finish, very briefly on the concession. The concession's been made in the First-tier Tribunal, the Upper Tribunal, and I've not resolved from that today. I can't see how. But that's the factual position. So it would be difficult for the Secretary of State to resolve, to change their position several years after the event, having made so many concessions in so many different courts.
Can you just help me with one bit of the First-tier Tribunal's judgment?
Certainly.
If you look at 44 and this serious concerns bit, which is the first criticism the Upper Tribunal makes, paragraph 44, line 2, there are serious concerns about the appellant's credibility for paragraphs 37 to 43. Can you just identify where the serious concerns are?
Yes, let me. So.
Because 37 is, it's plausible that he didn't keep a 2010 recruitment order.
Then 38, that there's no supporting evidence. And then the section 8 issues about late claim of asylum, which are the Upper Tribunal Judge was concerned because it was included in as a not having great effect, and included as being a serious concern in 44.
Yeah, and the point in 37 is at the end, because she accepts it's plausible that he wouldn't have kept the 2010 recruitment order, but didn't think it was plausible there would be no other evidence either.
Yes.
Mr. Keith, is that a convenient point to break off? I don't want you to feel you're
Well, my
under
Lord,
an obligation to rattle through final submission.
I have, I think, rattled through, my Lord. I mean, I'm happy to come back after
Well,
lunch.
because at the end of the day, your position is straightforward. You say the Upper Tribunal was right for the reasons it gave.
Yes, I mean, I'm happy to come back after lunch if you have any questions for me.
Yes. Now, each of you is going to think about supplying either a note or maybe some further case law. Do you want to both reflect on that over the short adjournment, please, and let us know when we resume whether you want to do it separately or whether you're in a position to help us now. Okay. Thank you both very much. We'll rise till 2.
Court rise at